Hi, all. The class for today is looking at basic procedure. Like, what are the steps it takes to investigate, arrest, interrogate, try, sentence, and appeal any case? And the reason this is important is rights don't exist in the abstract. Rights are attached to some step in this procedure. A right that exists at the point of custody may not exist at the point of arrest. A right that you have at sentencing may disappear once the sentence has been given. So it's important to understand that all of these steps are each a point where the Constitution may attach. This is why criminal procedure, the steps of procedure matter. As we talk about each case throughout this course, look for the point where the right came into place. And it's important to understand that courts don't have some general approach to all of this. They look at the application of a single procedure in a single case, and later cases look at the whole range of different preceding cases to look at is there a pattern for how to apply it. Now, the lawmaking structure in which all of constitutional law happens is based on the fact that we have 50 states, all with their own criminal code, and many local governments, which sometimes have additional criminal code. You have a general federal criminal code. But as happens in our system, 99% of the criminal docket and even 96% of major felonies are at the state and local level. And there's a whole diversity that goes across the states. And this has a whole history that the text goes into, from politics to other purposes. And but one of the things the federal constitution does is give some uniformity. And part of the debate over the 14th Amendment is it was trying to bring that uniformity to states in a way that has been fought over, as we described in the first class, since the Civil War. Now, the thing that we're going to look at throughout all of this is that there is a whole problem that when we talk about procedure, especially with police, we're talking about not just what did an individual police officer did, but how were they trained? What were the rules under which they operated? And one of the challenges in the US system is there are no less, by at least some estimates, 18,000 different agencies that have some policing responsibility. With that many different jurisdictions, it's easy to see a wide fragmentation of different training, different rules, different areas of discretion, which makes reforming the system often quite challenging. And you have to look at what are the different responsibilities? How were they hired? How did budgets affect all of this? Various sizes of these agencies, various differences in states. There are tiny states where the state attorney general, Alaska, Delaware, Rhode Island, have most prosecutorial power, while in others, city, county, district attorneys often have much larger roles. And again, there are 2,300 different prosecutorial districts out there. So, again, a lot of different patterns, a lot of different groups to be held accountable. With defense counsel, different states run that differently. There's, of course, private counsel, but even state funded counsel may happen either through staffed public defenders' offices, funding for local private attorneys to take it, or sometimes even an appointment system where the judge may rotate among a panel of approved attorneys. And again, with judges, there are magistrate courts with very limited jurisdiction, general courts of general jurisdiction, and even state appellates courts. The more limited jurisdiction courts usually just have misdemeanors, but there are felony courts that often take a much broader area. But again, the rules apply differently in different courts. And thinking about the steps, and without going in great depth, you go from pre arrest investigations, where people are being interviewed, and canvassing of neighborhoods, and investigating crime scenes. And you have to think about what constitutional rights matter there. Then there's the point of custody or arrest, and that's often the first place where many other rights kick in. There are, even after an arrest, there continues to be investigations, lineups, and police questioning of suspects. There's the decision to charge, and what are your rights when you're being told that you're going to be charged with a crime. There's the complaints and reviews of arrests in certain cases, and all of this can vary state by state on the exact sequence. And then when you appear before the judge, there's all sorts of issues of what kind of counsel representation do you have, how effective it's going to be, what are the rights around bail, and so on. There are preliminary hearings where there may be decisions on whether to move forward. In some cases, a grand jury may be brought in. In other states, grand juries have less of a role. And you still have to decide what kind of plea are you going to make, especially initially. If it's not a guilty plea, you have to move forward through a range of pretrial motions, pretrial discovery, and the question often comes up, when does the defense have right to know what the prosecution has? And we'll see cases where that exact point matters quite a bit, especially during the plea bargaining process. What rights do you have to get information before you make a plea bargain? You have trial, which has a whole range of different rights, different constitutional rules. I mentioned um, in the syllabus that we don't spend a lot of time on trial, partly because 90, 95%, sometimes more, depending on the state, of cases go through plea bargaining. Very few people see a trial, but there's still a lot of constitutional debate around trials. Then there's sentencing. And then there's issues of what can be appealed, because a lot of people would love to appeal, but they don't always have various rights. And then even when you're released from prison, there are often collateral remedies, issues of how you can have additional punishment in the form of rights stripped from you post sentencing. So all of this is going to be debated. Now, one other point, and this is the Michelle Alexander piece is somewhat separate, but it's a complement to thinking about what is the actual status, how does living under these set of criminal procedures affect, particularly by race in our society, how people live their lives. And for all it's done in an officially colorblind way, what Michelle Alexander argues is it creates a system of what she calls caste, where, once you are a criminal, you often have scarcely more rights than you did living in official Jim Crow. And so the fact that we have so many people put into that caste, especially based on race, is incredibly important. And it is worth noting, and I have mentioned this before, but by the numbers, the US has incarceration rates that surpass even highly repressive regimes like Russia, China, and Iran. Just unprecedented levels, and how that plays out, especially in the African American community, especially for young Black men in particular, who overall, the numbers are 1 out of 3 young African American men are in control of the criminal justice system, in prison, in jail, on probation, on parole. And that creates divisions in society that matter. And that's what the new Jim Crow argues. And it's not just that there's this undercased underclass. You end up, especially given the drug war, a whole set of people relegated to this second class status. And the question is, what are the strategies that could have avoided that? And part of what the new Jim Crow is doing is not just critiquing society, but critiquing the strategies of civil rights activists who were pursuing a very sort of Warren Court legal rights approach while ignoring broader political efforts to change the criminal justice system. So as we go through, it's worth thinking about the particular rights, but as William Stuntz notes, there are often much broader political contexts that matter for defendants' rights. And that's partly what Michelle Alexander is looking to move away just from these individual rights of procedure and thinking about the broader political context. In any case, enjoy the reading for the day, and we'll follow up in the next class.